I've got a list, a page of about 15 criminal law review symposia. What's a law review? A law review is a legal journal. How many legal journals are there in the United States? About 500. About 350 of them are associated with law schools. What these law schools will do is they'll write to some scholars and practitioners and judges and say, we want to do a symposium on the Reform Tax Code or on the federalization of criminal law. And we'd like you to all submit papers on this. So if I've got 15 symposia on that from 2001 to 2006, multiply that by 6 or 7 articles. But I can assure you there are hundreds of articles that have been written in the law journals about all of the topics under those causes and more. So there is a tremendous excitement in the legal community, in people who write about criminal law, criminal procedure, criminal justice for the legal community. Tremendous amount of excitement about wrongful conviction. I've got a list of about 8 or 10 articles by criminal justice people on wrongful conviction. So you would think that this would be a natural for criminal justice. And why is that disparity? Well, part of it says something about how legal scholars and criminal justice scholars work. Criminal justice scholars who are social scientists tend to become very, not exclusively, but the typical norm is that they become highly specialized, both on a subject matter and on the methodology. And it's probably harder to publish in a good social science journal than it is in a law review. And so they have to work very hard to generate articles that get published. And switching from what they normally do to this new area like wrongful conviction is not that easy. So even though there may be some generalized interest among social science, criminal justice folks, it's kind of a hard switch to make. Law professors, on the other hand, can write at some length about a variety of topics that are sort of legally grounded. I've decided some years ago to float around, and I've written about assisted suicide. It's a bit out of my field, but I was able to publish articles in that area. I've written about Miranda. I've written about you get old, you sort of forget this stuff. Asset forfeiture, that was actually for a criminal justice journal. And so, we can sort of flit around a little bit more. Sometimes it produces some nonsense, but there are just different styles. And I wanted to talk a little bit more about the differences, but I think I'll let that go and talk a little bit more about wrongful conviction, since to delve any further into the differences between law. I have a question, Dr. Garrison.
Well, maybe just a comment. I think to support the fact that there is a very different focus, probably EKU's in a graduate program instead of law school.
The only one that may also have something like that is Northern Arizona. Bob Scher. Yeah. Yeah, and I would think that a place that has a forensic science program would work closely. But Michigan State, where I used to teach, has a very fine master's degree program in forensic science. To the best of my knowledge, has no connection with the Cooley Law School Innocence Project, which is located in Lansing. Part of that problem may be that Cooley is by law limited. Law and agreement limited only to do DNA cases. So the scope of issues that students do in forensic science may not apply, in all fairness to them. All right, one of the things I said this morning, I don't want to go over it at length, is that how many wrongful conviction cases are there in the United States? Is it a big problem, or is it something that's really scary? You read about it, and you say, oh my God, that's terrible, but there are only 30, 40 cases a year.
My question.
How many are there?
Well, what portion and where in the United States, and why are they taking place, and what are we doing about it?
All right, so you want the whole thing about wrongful conviction in a shot. I can't talk about region. There are two ways of figuring out how often something happens. And if you think about crime statistics that you've studied in a conviction class, you remember the history of trying to figure out how much crime exists. Way back in the 19th century, they used court statistics. And then it dawned on people that by the time a case gets to court, that's not necessarily a good reflection of how much crime has occurred. So in the 1920s, the FBI, 1930s, started with crime reported to the police. And then scholars, sociologists, very quickly realized that there is the so-called dark figure of crime. Are people actually reporting crime? Are police manipulating the crime statistics? Now, crime reported to the police is the UCR figure. It is useful, but when the federal government started doing crime victimization statistics by actually calling people on a random basis, a scientific sample of the American public, they realized that the crimes reported to the police reported approximately 1/2 of the felonies that people were saying actually happened. And even the victimization survey data probably is not a true measure of crime. So part of the answer is, do we really know how much crime there is out there? The answer is really no. Do we really know? It's a lot worse with wrongful convictions, because there's no official, let me finish this up. There's no official body that counts wrongful convictions. That's part of the problem. The other problem is definitional. We can make an assessment that even though there's not been a conviction, when a person has had their house broken into, we can count that as an uncaught, assuming the person's not caught, burglary. We can register that as a burglary. The concept of a wrongful conviction is somewhat incoherent in American law. When a person is acquitted, that doesn't mean that they didn't do an act that might be deemed criminal. It means that a jury has found that there is that a person there isn't evidence that would prove guilt beyond a reasonable doubt. And jurors will often say, we think he did it, but we're going to be true to our oaths, and we are not going to find this person guilty. And juries take their job seriously in the U.S. for the most part, and they adhere to those standards. So if a person claims to be exonerated, prosecutors will often say, even after an appeal and a retrial and an acquittal, prosecutors will say, I don't care what the jury said, the person actually did it. So in some ways, it becomes virtually impossible to prove that a person did not commit a crime. That's why wrongful conviction, which was certainly known about for a long time, becomes a real topic after DNA exonerations.